Hey guys, so this is the whole hearing from HB496 Wednesday. You might have seen the summary of it, how we got there before 1 o'clock and actually ended up waiting till like 7 or 7:30 to testify. I'm not sure why the chairman read Jasmine's bill last. I definitely think it's kind of weird.
So Blair, people in favor, advocates say that this would give police clear, objective standards for how to handle people.
And though he says he'll probably going to vote on it on Monday, it's not on the website yet. So keep an eye on legis.georgia.gov.
Also, if you sign up to get notifications, you will get an email with the agenda like I got here, and I was so excited about it. But then it turned to TBA, and then it turned to this with like 13 bills on there, but not the one. And if you go on the website, it goes to TBD again. And these are the ones that we want on there.
We would like it to be
HB 804, 1248, and 496. And you know, I have this bill tracker online, so you can see what all the bills are and click on them to see. Speaking of which, 2 more bills were added to it. Senator Harold Jones II sponsored these bills to help with decriminalization as well as voting rights. So I decided to see when these committees were being held. I looked it up, and they're circled in blue. They're both in 307 Club on Monday, and both agendas are TBA. And just in case you didn't know, that little clipboard emoji is what you click on to see the agenda. So what you can do is you can go back to this bill tracker tool that I made and see who's the chairman, and then email those chairmen and ask for these bills to be heard, as well as your legislators, which you can find in that bill tracking link as well. And then you can also email those chairmen to get on the notification list so you know when bills are being heard, which is a little bit hard to get when it's close to crossover because everything changes last minute, like you saw last Wednesday. And yeah, I know what you're thinking. Sam Watson, Senator Watson, chairman of ethics, isn't he the one that said glyphosate was safe? Yeah, he did.
Getting tons. I'm sure we all are getting tons and tons of vote no emails. So can you give me some messaging pointers to the consumers who are gravely concerned about this bill?
I brought a visual aid. This book right here, if you want to take it home and read it, it will tell you how safe glyphosate is.
I'm a recent cancer survivor.
Speaking of crossover madness, I decided to just see what was going on in the committees. I clicked on the agenda for natural resources, and I saw that Sam Watson had a bill that not even the Georgia Water Coalition or the Sierra Club picked up on. He must have snuck it in there. Now, coordinated PFAS remediation. I like the word remediation because I know that hemp is an amazing phytoremediator, biodegradator, bioremediator of toxins, including PFAS, and you can see it was studied here. But I don't know. His track record of caring about the environment as much as I do is not really there. So let's read what it has to say. And those of you who understand legalese better than me, I would love it if you would get back to me. I am glad that it recognizes the danger of it, but are we not holding companies liable in this bill, or are we creating a phytoremediation program to clean our water? What are we doing? If y'all hadn't seen it yet, in my 2020 documentary Hempdemic 2020, which I don't think I actually edited completely until 2021, I don't remember. Anyway, there I talk about not only the dangers of PFAS now, but how if we didn't have a hempdemic and didn't illegalize hemp, we probably wouldn't even have the PFAS problem we have today. And I'll put some clips at the end of the video so you can see it, but also watch the whole movie to really get the gist of that. Let's take it back to the House Judiciary Committee meeting on Monday.
And you can look at the schedule, and please, you can write to your legislator, you can write to the chairman, you can write to the members of the committee if this bill is important to you and you want to see it pass. Also, not sure why the other 2 helpful bills for our freedom aren't on there. HB 804, sponsored by Almaty Hali, and 1248, the Freedom Act, sponsored by Derek Jackson. See, the reasons why this is important is because crossover date is coming up this coming Friday, and if the bill doesn't cross over to the other side, then guess what? It dies. So this is our chance for 2026 cannabis reform, and I think it's really important.
And I just showed you my notice about water conservation, that there is a hearing on Monday for HB496. It's a PFAS transparency bill that they like. So let's test your skills to be able to go onto the website and find where that hearing is. Probably in natural resources in the Senate also. Oops, there it is. Oh, cool. It's right there. So the folks will be there to speak on it too. Also, as far as we know, there's no session scheduled on Monday, so it shouldn't be affecting the times of the meetings like it did on Wednesday. But the agenda could change at any time. Okay, so what you didn't see is that we got there at like 1-ish or earlier to sign up for the 1:30 hearing. And then we got word that they needed to go into their House session for a while and that we would do the committee afterwards.
There's a lot of bills being heard today.
Please pause the video to read the letter.
Be pulled over for the smell of marijuana.
And for those of you who don't know much about the constitutional Fourth Amendment, it is our constitutional right to have privacy. And that law protects us from not being searched and uncomfortably, unreasonably questioned in our own property, especially.
All right, and last but not least, we have House Bill 496, Representative Jasmine Clark.
Thank you, Mr. Chair. I know the hour is late, so I'll make this quick. This is a pretty simple bill. This bill acknowledges that back in 2019, Georgia made hemp products legal, and because of that, that has created a little bit of ambiguity when it comes to probable cause. And so this bill simply states that the scent of marijuana, cannabis, or hemp on its own, so if that's the only thing, cannot be used as probable cause and stop, search, or seizure. And that is the bill.
You've had the shortest presentation.
Hey, it's late, and like I said, this is pretty straightforward. We're not doing anything fancy. This isn't a legalization bill or decriminalization bill. This is just a straight up, let's get the law in line with laws that we have already passed here in Georgia.
Okay.
And happy to take any questions.
We have members of fellow members of the party of Jackson coming to ask you questions. Representative Panich.
Thank you. Thank you for the bill. I've had too many cases where a stop was pretextual just to search, and that the odor of marijuana was the reason. But so you're saying an officer can't pull over somebody because of the scent. Once they are pulled over, if there was a different reason and the scent, they can identify it, that can be a reason for probable cause. It's just can't be the reason for probable cause.
Yeah, absolutely. So when it comes to probable cause, totality of circumstances, and I'm not a lawyer by any stretch of the imagination, so, but what this says is just using only the scent cannot be reach the level of reliability for probable cause.
Thank you.
Chairman Crow.
Thank you, and I'm going to ask you another one of those questions that you may not, I'm not a lawyer either, so we're in the same boat.
Welcome to the club.
But that same paragraph A starting on 11, it says that the scent of marijuana, cannabis, or hemp on its own, whether burnt or not, shall not provide a law enforcement officer with a reasonable suspicion or probable cause for a stop, search, seizure, or arrest. And sort of to her point, probable articulable suspicion a lot of times is used for a request for consent to search. Would this impact that that you can't use it for a reasonable suspicion to ask for consent to search the vehicle?
So I will be very honest, I am not 100% married to reasonable suspicion being in this bill, and so if it is the pleasure of the committee, I'm happy to strike that. I really want this bill to be focused on probable cause, and I just did not have an amendment prepared for that.
Okay, thank you.
Representative Holly.
Thank you, Mr. Chairman, and thank you, Madam, for being able to bring this bill. Just for the viewing public and for those who are seated hearing this, for what other ways are you familiar through which a approaching law enforcement officer is able to identify that the person could possibly be using marijuana or cannabis products that are illegal?
So if they see it. So we, at this point, have body cam, all these different things. There are lots of objective ways for a police officer to, say that I have enough probable cause for a warrantless search. But unfortunately, odor is very subjective. And so this would strengthen the probable cause for that law enforcement officer by them having something objective that they can look at. So if they see it, if the person is doing something else that gives them reason to believe that a crime is being committed, then that is fine. This law would not change any of that. It only specifically relates to the scent of marijuana, which again is subjective.
Thank you.
And not measurable.
No, thank you. I remember we both were here to pass House Bill 324 and House Bill 213. And so really, if we're just relying on that as a sole factor, then it could very well be said that the officer is smelling the suspect in the possession of something that is actually lawful.
Absolutely. So as I mentioned earlier, we did legalize hemp in the state of Georgia. The chemical composition of hemp products is exactly the same as far as the thing that makes the smell. It's terpenes and volatile sulfuric compounds, and that's where you get that skunk-like smell. That is consistent through all of these different products, including the ones that are legal. So the smell alone is not an indication that there's any illegal activity happening.
See no other questions. Thank you.
Thank you.
We have several signed up. Remind you, 1:30. And I'm just going to go in the order I have right here. Let's see, Corey Lowe.
I just wanted to use it as a demonstration, just to show you. Oh, I didn't know that.
Yeah, we don't
Okay.
use props.
No problem. Can I get started? It's 1:30
Yeah,
seconds.
go ahead.
Okay,
Go
thank
ahead.
you all for being here. I know it's a long day, and I have two different testimonies. They're both in your folder. One is from LEAP, which is Law Enforcement Against Prohibition. They've approved that testimony. And basically, I'm just here as a former DeKalb County police officer and one of the Allen Peak families who got the bill passed for kids with seizures. And my daughter was having a seizure in the vehicle. I sprayed the rescue spray that I can't show you all. And basically, the sheriff said that he smelled marijuana. We have the low THC card, and we have her nasal spray that was legally obtained from a dispensary. And they basically called the convoy, and K-9 and narcotics wanted me to buy fentanyl for them, said that they would let me go. I explained that there's no, in the 6 months of police academy, there was no determination between hemp and THC. There was no classes that we took that would tell you the difference in the scent. It all smells the same. And I tried to explain that to the officer, and he said, marijuana is marijuana is marijuana. It's all the same. It's all the same. And I said, no, sir, I used to be a cop. I understand that there's a difference. People take hemp, and I was in front of a hemp store, and I had the receipt. I did all the things because I also had a pack of CBD cigarettes that were legally obtained. They took those and basically just charged me with tampering with evidence and possession of marijuana. And I have my daughter's oil in the card, and we're patient and we're trying to do everything legally, but we had to spend $25,000 fighting the case.
Did you win?
Partially, I mean, because the sheriff said that there was destruction of evidence, and no one had on their body cam, no one had a dash cam, no one, out of all the officers, the K-9, the narcotics, no one turned on a body cam, and no one knows where the receipt went for the CBD cigarettes. They just sent me a letter, said I can come pick them up because they've determined it's CBD.
Okay.
3 years later.
Thank you. See
Yes,
no
sir.
other questions from members of the committee. Thank you for being here today.
Thank you. Thank you for having us. Thank you for your time.
Randy, you're on this one too if you want to come up.
Thank you all again. Randy McGinley, DA. Okay, there we go. I met with Representative Clark earlier today, and this isn't, I guess my point of view on this is I can't think of another situation in the entire law where we determine what is reasonable suspicion or probable cause other than the judge making that determination upon hearing the evidence in the case. And again, it is a weird thing to come up here and say I'm not sure that the legislators, I caution saying that, I guess, but to me that is a judicial determination. Is what is reasonable suspicion, what is probable cause, is based on what the judge determines it to be. And to say it is, there are subjective things that are considered. Somebody's body language, someone's actions are subjective. And I guess if we're going to say that if it's something that you can't see on video, then you can't use that, that seems, we're saying, a law enforcement officer saying they smell it, we're just not going to trust what they're saying in any situation. And, you know, because you can, frankly, if you look at something with your own eyes and on a video, and you're asked, is that marijuana or is that hemp? Even though it's on video, are you going to be able to answer that question? I don't know if you are. So it just seems, to me, it seems a strange thing to limit this situation of just to a smell. And this will be the first time in anywhere in the code section I can find where the legislator is telling courts what is reasonable suspicion, what is not reasonable suspicion, what is probable cause, what is not probable cause. And I just think it's a strange situation to wade into for the legislator. Again, and if I could just finish real brief, just real quick, is, you know, the hemp, what is legal and what is not legal with hemp? There's some readings of it that you need to have a license to possess hemp. It's hard, and I don't know how to say this respectfully, is some of the changes in the law to marijuana and hemp and everything for the last 6 years has made law enforcement and prosecutors' job very hard. Because it's very, very hard for us to know what we can do, what we can't do, what we can prosecute, what we cannot prosecute. And overly complicating it more is maybe not the way to go, in my opinion.
Look like you got a question, Chairman Gullett.
If we were to strike reasonable suspicion, so it just would basically provide law enforcement, shall not provide law enforcement with probable cause for a stop, you would say that makes it better, am I right?
I would agree it makes it better. I still have some of the same concerns.
Sure, you still have concerns, but it makes it better.
I think that's fair.
Okay, thank you.
See no other questions. Thank you again.
Enforcement anytime I can, because that's my background. Essentially what they're saying is they're making it impossible to make a case for marijuana. I mean, if you're on a stop, on an automobile stop, if you smell it, they're burning marijuana or burning a product in the car, you should be able to approach to see if it's marijuana or not. If they don't, you've legalized marijuana, or an officer can't make a stop and can't make an arrest. I mean, I can't see how you can go forward if you can't articulate reasonable suspicion and probable cause. Can you see a situation where they could?
I guess the concern with that, and I'm not trying to put words in your mouth, but if you can't approach somebody because of the smell, how can you do those other things other than the smell? If you can't even approach somebody when you smell something to be able to see it, to be able to see their manifestations, I think that limitation is the concern here.
And it appears that there may be a step someday soon where we just legalize marijuana. But that's not done yet, and until that's done, it's you're stepping into the purview of the review from a judicial officer. Don't you agree with that?
That's my concern, is this will be the first time where the legislature stepping into what's reasonable suspicion and what's probable cause.
Thank you.
Lighting up like a Christmas tree up here. Let's see, number 8, Representative Kendrick.
Thank you. I was trying to understand, so you're saying if somebody is driving in a car and you see something that might look like marijuana, you don't think that the officer is going to be able to pull them?
Well, if you see it under this bill, it's perfectly fine.
Right.
But if you just smell it, it's not okay.
Right. So I'm trying to figure out, so you want law enforcement officers to be able to smell hemp or marijuana, whatever that smell is, and to be able to pull someone over and to confirm that it is the marijuana and hemp under probable cause or reasonable suspicion.
I guess just my opinion is that I think courts should make the determination of what is reasonable suspicion and what is probable cause.
Okay.
That's my take on that.
Okay. So there's no way that we can make this bill better, in your opinion? You're just against the bill just as a policy reason?
I mean, I guess to what Chairman Gold said, it's hard to say. If you say, will this make it better or worse, I'm going to be truthful and say this makes it better or worse. But I don't. I just think that is, again, I've never seen a situation in the statutes of Georgia where probable cause reasonable suspicion is defined by the legislature. That's not anywhere else in our code section.
Okay, so as a policy reason, you just think we should?
Well, I think that is a determination that a neutral magistrate or judge, should make.
Just against the bill, period. Okay, gotcha.
Okay, number 5, Representative Panich.
Hi, I'm having a little challenge with this. This isn't in court. This is on the side of the road where the officer would have a car go by, I guess smell something, and then use that to stop the car. We're saying that the smell alone can't be your reason to stop the car. But this isn't a judge making this determination. This is an officer on the side of the road in the moment making the determination.
Well, but I guess in my world as a prosecutor, how does that come up unless there's some arrest made and then it comes into court? And I guess that's where I'm viewing this as like a motion to suppress sort of issue, is where and maybe I'm looking at that wrong, is only limiting it to that. But if it comes to court and it gets challenged, that's when this would come up.
Yes, but we're also telling officers not to pull people over if the only thing they have is the smell of a car going by. And so, yes, if somebody got arrested, they'd file a motion to suppress under the Fourth Amendment, and then you'd have a hearing. But we're trying to stop that by saying, officer, if the only thing you have is smell, that is not to be considered as probable cause.
I guess, and along the same lines, this would be the only situation where I can think of where we're telling law enforcement, this thing is illegal, but if you have some evidence of it, you can't use that. And that's just, again, that's strange to me. Like, we're not trying to, like, at least in this bill, we're saying it is still illegal. And so we're trying to limit what is the level of evidence that an officer can then be involved in that situation when because, I mean, again, reasonable suspicion is not, beyond a reasonable doubt. Right. It is reasonable suspicion. And so I think just defining that, I just don't think that's appropriate. I think that's, I don't know. I guess from a policy perspective, I find that strange that the legislators wading into what is and what is not reasonable suspicion or probable cause.
Okay, I mean, we tell judges what they can include or consider or not consider all the time. So I don't know that maybe it's odd for that particular burden, but that's what we do. We make the laws.
Sure.
Thank you.
I know he's so much fun to spar with. I mean, I enjoy it myself because he's such a worthy sparring partner. So let's wrap this up. I'm going to take these last 2 questions. Representative Holly.
Thank you, Mr. Chairman. From what I've heard you, in terms of, it almost seems like the scent alone, you see it as that it can be actually an initial identification of something illegal. And because of the legislation that we passed, do you consider it that actually it could be very well, it could qualify something legal. And so because of that, and by asking that, you know, when I look at line 15 and I see the two words, based solely, does it not maybe, is it considered that maybe the officer might follow up with a sobriety test?
Well, and as a prosecutor, I would hope they would. I mean, I would tell law enforcement they need to do more than just one thing. But again, I go back to we're saying that smelling something is not enough, but seeing something is. In reality, that's not always true either, though, right? Just because you see some white powdery substance, does that mean it's cocaine or meth or heroin or something that's not illegal? And so if we're going to say that it's okay for officers to see something based on their training experience, then why are we going to limit it and say that if they smell something, they can't do that?
So you would feel better if there was actually in there where it would specify that, or you could add in that the looks of it beyond just the smelling of it would have to be necessary. So that basically you'd have to put in. Sorry for making.
No, you're okay.
You know, but just it would have to. You wanted to make sure that it is actually included in here that if you take out the reasonable suspicion part, then you could still have the officer be able to determine probable cause by other means beyond just the smell of something that is actually legal.
Right, and that's why I said to Chairman Gold's question is, would that be better in my opinion? And my answer was yes.
Okay.
Yeah. Thank you.
Chairman Crow.
Thank you. Obviously, you're aware of my background, and I have a different perspective on it than some of my colleagues. And it is true that if you smell the odor, you may or may not, an officer may or may not be able to determine whether or not it is marijuana or hemp or something else. But my concern is if we make a policy decision that there could be something illegal going on, I think it is, I don't like a policy perspective that says it may or may not be legal, to tell the officers in that they cannot investigate or stop to determine whether it is legal or illegal what is going on. An example I used earlier when I was talking to some of my friends that are here in the back there, we had a good chat at the ropes. When I was working, if I smelled, if I saw a car go by or was behind a vehicle or whatever, saw smoke come out or smelled the odor coming from that vehicle as I was driving behind it, stopping that vehicle, if they are smoking marijuana in that vehicle going down the road, there is a high likelihood they are driving under the influence of marijuana, and that needs to be stopped to be investigated. And so I think telling officers that they cannot use that as a determination to at least take that next investigatory step, I think is dangerous policy, because I think that we need to err on the side of giving them more tools rather than less tools. You know, I think that it did complicate things when we legalized hemp and some other things. I say we, I don't know that I was here when that happened, but maybe we should revisit that as whether or not that's legal or not. So,
if I could add one thing to that, just very briefly, is there are a number of substances that you can legally take, but you don't need to be driving under the influence, even though they're legal.
Thank you.
See no further questions.
Thank y'all.
Thank you. All right. Several signed up. Let me get to it. Brian Rashad. Okay, all right. He didn't say which one he signed up for, so I wanted to check and see. Omari?
That's me.
Come on down.
I know it's late, so I'll keep it brief. Thank you for your time. So I want to be very clear about something. HB496 does not prevent law enforcement from doing their job. If there is impairment, unsafe driving, illegal possession in plain view, or any other objective evidence, officers still have the full authority to act. What this bill does is remove Aroma alone as justification, right? That's the part that we keep missing, right? Law enforcement can still do their job. There's something that is legal here that does not smell different from marijuana. So while folks say they can tell the difference, scientifically they cannot. This is not anti-police. This is pro-clear standards. Clear standards protect officers from bad stops, bad searches, bad cases. They also protect citizens from unnecessary encounters that escalate simply because of a smell that could come from a legal product. I'm in favor of police standards and giving police all the tools they need, but I need them to also have objective standards. Thank you.
I see no questions. Thank you. All right, next I have Miss Yolanda Bennett. Come on down.
Good evening. Thank you all for waiting around. Oh, my cane. Yes, it woke some people up. I went ahead and I'm gonna keep this brief. My name is Yolanda Bennett. I'm with the Georgia Medical Cannabis Society. I know that you all may have in your packet, our packet that we sent over with the different laws that have already passed in other states that would prevent law enforcement from having it probable cause by the scent alone. I want to go ahead and share with you. You continue to mention hemp. Georgia has passed the medical cannabis low-dose THC program. That right there smells like hemp, cannabis, because it is. Cannabis is one plant. So, to move further, also last year, SB 244 passed. This right here, if this legislation is passed, this would allow the state and other DAs from not being liable for false accusations when it comes to the smell test alone. So basically, it will save the state money. And also, it would protect constitutional rights, the Fourth Amendment right. I've also shared the different cases alone, including the Fifth Amendment right. Now, if the product is seen out in public view, yes, they can arrest whatever they choose to do with it. But the smell alone is subjective. I myself am a medical cannabis patient, and I can't smell cannabis. Just telling you. I can smell gnat I can smell dust off a gnat. But anyway, any questions?
Number 17, Mr. Bill Fincher.
Tell me the group that you represent, please. What's the name of that?
The Georgia Medical Cannabis Society. I am a medical cannabis patient, a former correctional officer, so yes, cannabis, I used to believe that cannabis was a gateway drug.
Now, you heard the district attorney who was here a minute ago talk about if someone's under the influence of a drug and you need to investigate that, it could save someone's life if they're incapable of driving to the point they can't drive or be unsafe driving. Did you not hear that?
Yes, I did hear that. However, the thing is, when it says that's incapable or having some issues with driving, the police has other measures to determine whether or not if that stop is probable. Meaning, if the person swerves, that means they have the DEI, I think it's like a drug enforcement, is some kind of special test that they give you. Drug identification of the impairment, what you're having. So they do have special tests for that. So the probable cause of smell is subjective. And as you see in the packet, there is also some chemical smells that can come through the pores. That's another thing that with the medical cannabis program that we have now, some patients are afraid to participate because of things like this, being pulled over for cannabis, leaving the dispensary for cannabis on this possibility of the smell. So basically, in a sense, I'm speaking out for medical cannabis patients and the fact that patients like me, patients like Corey with her daughter, to be pulled over, we're already sick, we're tired, and we don't, just the inconvenience of having a police officer to go through our things. That's the thing. You have to put it in the patient's point of view. With a patient's point of view, you have to look at the fact like, look, I'm already sick. I'm taking my meds just trying to live, but I'm going to get pulled over by the police. So our concern is to make sure that we protect all people without being subjected to, the smell, because you have the Fourth Amendment right. So if you smell something, just like in the Leary versus the United States, he had probable cause, they pulled him over, which that one particular case overturned a law that had been in state since 1937. It overturned the Marijuana Tax Act. Can you imagine if you do pass this, how many different other people will be saved from lack of funding from the public defenders? The public defender's office is already overwhelmed. The prison system, I'm a former correction officer. The prison industry is overwhelmed. So overall, by passing this legislation would benefit not only the person who might not be able to afford, but the impaired driving training that that police officers are already trained with. So that's pretty much it.
Thank you. No further questions. Appreciate
All
you
right,
being
thank
here
you.
with us today.
This is my camera.
Okay, Ms. Viva, come on down.
Hi, my name is Aviva Vuvuzela with the Georgia Hemp Economic Revival Organization. Thanks for having us here on this very late hour. I know you don't want me to hand this out, but if anyone wants to approach me later, I have hemp pre-rolls that not only smell like marijuana, but to the DA's point, they also look like them. So does a bag of chips that has THC on it. So I understand that dilemma there. I just want to remind you that this bill does not allow driving while being intoxicated. It does not encourage underage smoking, and it does not remove this, once again, as a contributing factor if there's other issues at hand. There are so many states that have already passed this legislation. Obviously, all the legal states, Michigan, Arizona, Connecticut, Colorado, Florida, Illinois, Maryland, Louisiana, Massachusetts, Minnesota, Mexico, New Jersey, New York, California, Pennsylvania, Vermont, Virginia, Oregon, and so many more. We've got 300,000 tourists coming for FIFA. I think we might be smelling something very legal, and we don't want to flood what's going on. The other thing that can smell like cannabis is sage, which I love. You burn sage sticks to clean environments, and I've been approached because I do sage my car, especially after passengers sometimes. Medical cannabis, obviously, and a cigarello can be confused. I also read about phantasmia, which is when you have traumatic brain injury, you can have a fake smell come up, which I think might be even more common amongst officers because they go through trauma as well in So I'll yield to Scribbles if you'll let me. He has one thing to say.
I'll allow it.
Injustice anywhere is a threat to justice everywhere, and I just think we need to get some serious schnoz testing going on if we're going to be depending on smell testing alone. Thank you very much.
All right, Chris Bruce.
I can be honest with you, when I woke up today, I didn't see that one coming. Okay? Every day is something. Mr. Chairman, members of the committee, my name is Christopher Bruce. I'm the Deputy Executive Director of the ACLU of Georgia. It is a pleasure to talk to you at this late hour, and I will get right into it because I don't think there's too much that we disagree on. We know that Georgia has legalized hemp and other certain forms of medical marijuana. We also know that these produce smells that are indistinguishable between cannabis and marijuana. So, looking at it when lawful and unlawful substances share the same scent, smell ceases to be a reliable indicator of illegality and cannot itself justify police intrusion. Let's go into the court cases, because we know in certain frameworks where there are other states who have passed this law. This is where you do have a handout for House Bill 496. Places such as Florida and Pennsylvania, where hemp and medical marijuana are lawful, but recreational marijuana remains illegal, like here in the state of Georgia. Courts have held that odor may be considered as part of the totality of circumstances, but it cannot alone establish probable cause for a warrantless search. Officers must point to additional objective facts suggesting that crime is occurring. This approach is consistent with a decision made by the Michigan Court of Appeals, which concluded that marijuana possession may be lawful. Odor by itself does not establish probable cause. Instead, law enforcement must identify facts indicating unlawful possession. The same reasoning applies right here in Georgia. Because legal cannabis-related products can smell identical to illegal marijuana, odor alone is too unreliable to justify a stop, search, or seizure. House Bill 496 provides clear guidance when it comes to this. And with that, I urge you to pass this bill. I will also yield for questions. I am also a criminal defense attorney with over 10 years of experience. That's right. So these type of cases, including when it deals with the vehicle stops, police officers have over 20 ways of stopping you already. So if we know that you are swerving in between lanes, if anything else has happened, they can stop you for that reason. Odor alone should not be one of them.
I see no questions. Thank you, sir.
Thank you, Chairman.
All right, and I believe this is the last one on the list, and not least, Aaron Jimenez.
My name is Erin Jimenez. I'm a cannabis advocate. Thank you for having me. I know it's been a really long day, so I'll try to keep it brief. In my advocacy, I did a lot of work on decriminalization. Oh, thank you. A lot of work on decriminalization in Athens, and we really wanted probable cause for the smell to be removed in Athens, Clark County as a part of that. We were actually advised that it was not in our best interest because a lot of jurisdictions are simply throwing their hands up because they know that there's a lot of complication in regards to what the smell of marijuana is. So frankly, I think this would clarify things for police officers. My colleague, who was unable to be here, has testified in 5 cases in Athens and the surrounding areas as to the smell being subjective, and to my understanding, in every case, he brought CBD flower, which was perfectly legal at the time. Pre-rolls are now legal now. And once the judge smelled it, they threw the cases out. If we don't have to travel to every courthouse in the state of Georgia, that would be incredible. But I do want to say that it also hurts small businesses because even though our products are federally legal and state compliant, sometimes customers are afraid to even buy it. Like, they come in out of curiosity, they're clearly interested, they have needs for it, but they walk back out because they don't want to be harassed based on probable cause. And I can tell you, as someone who used to work in a hemp dispensary every day, that was a big concern of mine, was simply working in that environment every day. I did smell like marijuana. So even if I did not partake, which I typically don't until the end of the day, I could be stopped and I could be searched. And I don't think just for going to work, I should have that fear in my head. So again, I support HB 496, and thank you for your time.
You got a question, Representative
Second,
Fincher.
and you just testified to us that you knew that you smelled like marijuana, did you not?
I did, because hemp and marijuana smell exactly the same, and I worked in a hemp dispensary, not around marijuana, to be clear. Are there any other questions?
Seeing none, thank you very much.
Thank you.
Representative Clark, if you want to come up and say one last word. I don't think I missed anybody, did I? Anybody else want to testify? Oh, yep. Representative Clark, hold on a second. Yes, sir.
I'll be quick. My name is Mr. Sully Sullivan. I'm with the Veterans for America First. I'm a national ambassador. Mr. Chairman, members of the committee, I rise in opposition of this bill because while it may be well-intentioned, it creates serious unintended consequences for public safety, law enforcement operations, and judicial clarity. One, it undermines the established probable cause standards. For decades, courts across the country have recognized the odor of marijuana as a legitimate factor in establishing probable cause under the totality of the circumstances standard. Removing that tool does not modernize the law, it weakens it. Officers rely on sensory observation, sight, sound, and smell. As part of constitutional policy, the bill artificially removes one of those recognized indicators, making lawful searches more vulnerable to suppression challenges. 2, it creates a practical enforcement confusion. Hemp and marijuana are visually and olfactorily similar in real-world roadside encounters, but officers cannot reliably distinguish between them based solely on smell. By prohibiting reliance on the odor, criminal actors gain a built-in defense. Officers are forced into hesitation. Prosecutors face higher evidentiary burdens. This bill creates ambiguity where clarity is essential. 3, it increases risk to public safety. Drug-related stops frequently uncover illegal firearms, trafficking operations, and impaired drivers. The odor of marijuana has historically been lawful starting point for uncovering more serious offenses. Limiting that authority could prevent lawful investigations that remove dangerous individuals and contrabands for our community. 4, it would increase the litigation and court backlogs. This legislation invites expanded suppression hearings, challenges to officers' testimony, appeals on probable cause determinations. Instead of simplifying criminal procedure, it adds layers of litigation that burdens the courts and prosecutors. 5, it sends a conflicting policy message. If marijuana remains illegal in certain quantities or circumstances, but officers are stripped of tools to enforce the laws, the state sends a contradictory message. The law exists, but the enforcement is constrained. If policy goal is to reform, the conversation should be addressed directly, not indirectly through procedural limitations. In my conclusion, members of the committee, this bill reduces clarity, increases litigation, and weakens a long-standing investigative standard without proving a workable alternative. Although I do agree with recreational marijuana, but this bill is weak because there's a difference between recreational marijuana and THC.
Thanks, sir. I see no questions. Thank you. Now, Representative Clark, you want to come and give us the last word?
Thank you, Mr. Chair. I really do appreciate the committee's time and consideration on this bill, and I would ask that this committee consider passing this bill. The purpose of the bill is to provide clarity. As has been stated by many people who have come to this podium, there is plenty of case law that establishes that once you make any form of cannabis product legal in your state, then the smell or the scent of cannabis can no longer be used as the sole probable cause. I also want to reiterate that the purpose of this bill is to strengthen the evidence that can be used if a person is in fact committing a crime. We do not need subjective things that, again, could completely be legal, muddying up cases for our prosecutors. We want to make sure that they are using objective, verifiable evidence in these cases. And so it's a simple bill. It's like a page and a couple of sentences. And again, I am completely open to removing reasonable suspicion from the bill. If that is the pleasure of the committee, I have no qualms with that. And again, I hope that you all will consider this bill for passage. Thank you.
Thank you, Representative Clark. All right. So we've lost quorum, so what we'll do is we'll bring this back up probably Monday. I'm going to cancel tomorrow morning's meeting. That was just a fail-safe in case we didn't hear any if we were not able to get the bills today. So no 8 o'clock meeting in the morning. Have a good evening. Thank y'all for your long suffering here in Judiciary Non-Civil. We are adjourned.
Thank you all so much for watching this entire hearing. I think it really helps to get the juice and the meat of the matter in our brains.
So yeah, y'all, thank you for watching. Please subscribe, please share, please like, and please donate if you can, because we really need to be teaching Georgians how this legislation works, how the legislative process works, so that we can all get involved, and they won't know that we want something unless we show up and tell them that we do. That's how it works. See you there.
Let's watch some of those Hempdemic clips about PFAS.
They're beginning with marijuana, and they want to legalize eventually all drugs. Anything. You could say, let's put laxative in the water. If it makes somebody feel good.
Doctors came in and started asking my husband and I very pointed questions. Where do you live? Where did you grow up? Did you or your husband ever use or work with chemicals or pesticides? What's going through your mind? I immediately started looking into environmental causes.
The military firefighters in the foam were magnets for children. Here spraying kids at a fundraiser in 1982. Across the country.
What did Andrew Wheeler, our current administrator for the Environmental Protection Agency, do in 2019 that upset so many people? Said that he decimated the EPA. I guess it's more what he didn't do. He kind of just sort of probably maybe left the EPA's limit of 70 part per trillion health advisory level for the chemicals PFAS, PFAS, poly and perfluoroalkyl chemicals, especially perfluorooctanoic acid and perfluorooctane sulfonic acid, as a safe level for drinking water, which is about 6 times higher than what the disease registry considers safe. It was a great weed suppressor. And since that time, the chemical dependency of farms has been progressively secured, while non-chemical approaches have basically been beneath everyone.
Get ready.
Making the former tie-dye people look credible
Next,
and knowledgeable.
we will hear from Aviva and Scribbles. You got 3 minutes. Give it all you got.
Thank you. I really appreciate that.
Now, in 1943, he said,
"We recommend hemp as a weed control crop. Its dense, tall growth helps to kill out many common weeds. It's the best smother crop for assisting the eradication of quackgrass."
And Mr. Wright, back in 1918, said,
At Waupun in 1911, hemp was grown on land badly infested with crackgrass, and in spite of an unfavorable season, a yield of 2,100 pounds of fiber to the acre was obtained, and the quackgrass was practically destroyed.
And in Holland, there was this study.
We tested 5 crops in a study to suppress weeds. Our target was yellow nutgrass propagated by tubers and hard to control. Hemp was the most competitive crop in this study.
Now, I can only imagine, with its trichomes, oils, and thousands of natural chemical components, what kind of products cannabis can make to help with farming practices. People, the future is beautiful. These studies will not be suppressed for too much longer. I kind of think our lives depend on it. I guess it's more what he kind of just sort of probably didn't do.
A lot of cancer happened here. This house had cancer. My 2 childhood friends also had children with cancerous brain tumors.
Hope Gross and Joanne Stanton say this is the toxic legacy of their childhood. Revealed chemicals known as PFAS, used in the foam, had seeped into the area's drinking water.
What's inside?